Thanks, Joan. I'm a lawyer here in town, and I've been a lawyer for about 20 years, but I've been practicing here in Nevada County for about 5 years. Before that, I used to practice down in Los Angeles, and then took a long hiatus to travel and go back to tax school and do a number of other things before I landed here. And I'm just real glad to, I'll say this, I'm real glad to be here. It's a real pleasure to land in Nevada County. I kind of wake up every day and pinch myself to see how lucky I am to be here. And these events are really useful. I've done this talk before and have thoroughly enjoyed it. I kind of run things sort of informally, which I think is helpful, and I'm going to sort of get through some of this material as quickly as possible so that you can ask questions, because I found that that's always very helpful in terms of prompting some additional thoughts about, you know, what can be a complicated regime, but which is important for virtually everybody, because at some point in time everybody's going to end up owning some kind of real estate, and then the question becomes, what do you do to make sure that you can, you know, protect your rights? I've structured this as a kind of two-part presentation, and I'll be happy to concentrate on one part or the other. The first part, at least with respect to the title of the seminar, is the Homestead Exemption, but the second part concerns asset protection, and they're both the same, really in the same ballpark, with the Homestead Exemption being a portion or a part of a plan of asset protection. But there are some other aspects of the handout which I have indicated are some things I can talk about in terms of setting up some structures and doing things other than just taking care of your Homestead Exemption. I'll be happy to concentrate on one or the other, and what I'd like to do is just kind of see a show of hands of people that would like me to deal first with the Homestead Exemption. That looks like that's more or less a majority. So I'll just launch right into the Homestead Exemption. Then if we have some time, we'll talk about some of these other asset protection strategies. First of all, let me make a correction to my materials. There are 3 Homestead Exemptions, and if you are a single person, the amount of the exemption is $50,000. That's in all of these statutes are in the California Code of Civil Procedure, section 704.1 to 704.995. So we'll start if you're a single person, it's $50,000. If you're a married or head of household, it's $75,000, so that's the same. And if you're age 65 or older, or if you have someone in the house who is a dependent, say somebody who's disabled or someone who's drawing a disability benefit, then the legislature has actually increased the amount of the exemption from $125,000 to $150,000. So that's a correction to my notes. Some of these are a little bit dated. Periodically, the legislature will revisit these exemptions because, you know, unfortunately, they haven't revisited them as quickly as real estate prices have gone up. But you know, there's pressure periodically to come back and revisit them. And typically, when those bills get introduced in the legislature, they are opposed by lending institutions, and not because lenders are afraid when they advance money for mortgages or consensual liens, but because they're selling credit cards to people, and if they get a judgment against somebody on a credit card, then that does fall under the protections of the Homestead Exemption. So, having said that, so what is the Homestead Exemption? The exemption does not mean that your principal residence. Well, first of all, let's talk about what it applies to. It only applies to your principal residence. Okay. So you can exempt one piece of real estate, and that can be a condominium, it can be a piece of land, it can be a fractional interest in some sort of place where you live. It can even be, under some circumstances, a modular home that's located on a piece of property if you have a long-term leasehold on the property. If you have a leasehold of less than 2 years, then the Homestead Exemption does not apply, and the mobile home would be treated just like personal property. A creditor that gets a judgment against you can go ahead and levy on that just like it could a car or something else, subject to the other exemptions for personal property that are provided in the Code of Civil Procedure. So the homestead exemption only applies to a dwelling. You actually have to live there, okay? Or let me rephrase that. You have to live there for continuously from the time that you bought it until the time that the issue of the homestead exemption comes up. When does it come up? When you get a judgment that's taken against you and somebody is seeking to either enforce that judgment to collect money from you or to seek to have the dwelling sold, okay? So it may or may not, the exemption itself may or may not prevent your home from being sold. And let's just use that as the easiest example, because I don't want to get into other complicated forms of ownership right now, just so you can get the concept down. If you have a home, then you're entitled to keep a portion of the equity in the home. You're not entitled to keep the home if somebody has a judgment against you and they record that judgment and then it attaches to the home, okay? So that's the first thing to bear in mind. The exemption only protects a portion of the equity that's in the home. And it protects it according to whether you're married, whether you're single, whether you're age 65 or older. So you get, it floats. Depending upon what age you are, you may get more, you may get less. And the idea behind it, the theory is that if somebody is about to lose their home as a result of a judgment that's taken against them, involuntary judgment taken against them, then the legislature doesn't want to leave people completely penniless. We want to give you an opportunity to be able to have some money out of your home so that you can go and perhaps buy something else or at least go rent an apartment or do something of that nature. Okay, so let's see if I can get the priorities down. First of all, the exemption does not affect consensual liens, all right? So if you have a trust deed against your house and you go into default on the trust deed, the consensual lienor who holds the trust deed can then foreclose on the home and they don't have to pay any attention at all to the homestead exemption. Because if they notice the home for sale, typically if you go through non-judicial foreclosure, then they record a notice of default and then you've got 90 days in which to try and sell your home, and if you can't sell it after that 90 days, then at that point in time they advertise it for a series of weeks after that 90-day period, and then it'll be sold on the courthouse steps. The secured lender who has a trust deed can sell the home, and if he sells it, then he can only get paid what he's owed on his trust deed. Anything over and above that goes to you. If you've got a judgment creditor who has recorded a judgment against you, and you have a declared homestead, well, if the property does go into foreclosure, because typically people that, they tend to have these things happen all at the same time, then if it goes into foreclosure and it's sold on the courthouse steps, at that point in time, whatever comes over and above the sale price would be turned over to you up to the amount of the homestead exemption. So let me give you an example. Home is worth $200,000. You've got a trust deed against it for home is worth $200,000. You've got a trust deed against it for $100,000. You go into default on the $100,000 in the trust deed, and then you have a judgment creditor that's recorded a $25,000 judgment against you. You're single, so you own the home. If it goes into foreclosure and it's sold on the courthouse steps and it sells for $200,000, then the secured lender would get paid the first $100,000 coming out of that because property's in foreclosure. The next $50,000 would be paid to you as your homestead exemption, and the remaining $25,000 would be paid to the judgment creditor. So the homestead exemption actually establishes a scheme of priority if a house ever does go into foreclosure. That's one scenario. Now the other scenario would be something like this. If you have a judgment creditor that gets a judgment against you and he records a judgment and then he notices the house for sale, well, there's a series of things that he has to do in order to get an order for sale of the dwelling, all right? And what he first of all has to do is he has to apply to the court to get an order for sale. And then the court will hold a hearing to determine first of all whether the dwelling itself is a homestead. If you have a declared homestead, you've recorded a declaration of homestead, then that is prima facie evidence that that is your homestead, and the court goes no further into asking whether that's actually your homestead or not, unless you've recorded homesteads on some other pieces of property. If you've done that, then the court's going to force you to make an election as to which of these properties is actually your homestead. Okay? So, After that takes place, you apply for the order of sale. Well, then, if the court finds, the court is then required to determine what is the fair market value of the property. And that would be based usually upon some kind of an appraisal that the court would order to have done. It's a question mark as to who pays for that appraisal, but presumably it would be part of the cost of the sale that would come out after the property potentially may be sold. Now, if the fair market value of the property comes back and it's less than 90%, let's see if I can, this gets complicated. So, and this is found in, I'm going to turn right to the statute here. Let's see. If you look in the back of the handout, it's in 704.800. If there's an order for sale of the dwelling, and the top bid at the sale comes in at less than 90% of what the fair market value is as established by the court, then the property doesn't sell. So the bid has to come in at more than 90% of what the value is, regardless of whether you have a homestead exemption or not. Okay, so it's possible that if your house is noticed for sale, an involuntary sale, then it may not be sold because nobody's going to bid up to that floor. So that's the first part of it. The second part of it is that if a sale is ordered, well, the court's going to have to make a determination as to what the judgment creditor might ultimately end up with if a sale of the dwelling is ordered. And the priorities for that are in section 704.850. And I've listed them in terms of what the priorities are. What has to happen is that after the fair market value of a dwelling is established, then the first thing that comes out are the consensual liens and the mortgages. So you take that amount of money out from the fair market value. Then would be the homestead exemption. So whatever that amount is comes out next in terms of determining whether the property could be sold or not. Third would be the cost of the levying officer. And then finally would be the judgment creditor costs and amount due on the judgment. Okay, that's item number 4. So the priorities are important because that determines in a very real sense whether your house could be sold if it was levied against. And it goes like this. If you have again, using our example, if you have a house that's worth $200,000 and you have a trust deed of $150,000 against the house, and then you have your homestead exemption at $50,000 because you're single again. Well, in order to determine whether there could even be an application for an order for sale, what the court would have to do would be to have to look at the consensual liens plus the homestead exemption to determine whether the judgment creditor would ultimately end up with something in his pocket after the building was sold. Okay, so in our example, if you've got a trust deed for $150,000 and your homestead exemption is worth $50,000, then if the property were sold, including your homestead exemption, then the judgment creditor wouldn't get anything. And since he wouldn't get anything out of a sale, then the court would not allow the property to be sold. That's effectively how it works. So the implied message here is something like this. If you have, if it looks like you're about to be sued, and you know for certain that there may be a lawsuit that's coming down, or if you've done some advanced planning, if you have a trust deed against the house and the trust deed is upwards of, is up to the amount of the fair market value of the dwelling plus the homestead exemption, then you really don't have to worry, at least at this point in time, if a lawsuit's filed, whether your dwelling would actually have to be sold if a judgment were rendered against you. Now, there's a subtlety to that, and it goes like this. What do you do in the case of a rising real estate market? Because it's a moving target, especially in California. So a homestead exemption that was put in place, or a homestead declaration that was put in place many years ago, and a trust deed that was outstanding many years ago, may not cover the full amount of what the equity is in your home. And so what are people doing if they're thinking real intelligent? They're going out and they're getting home equity lines of credit. And what that does is that it establishes a priority of a trust deed without actually taking the money out. You pay some loan origination costs and just to get the thing set up, but then once the bank records its trust deed against the home and you have an open line of credit, then it's possible to then draw down on that line of credit and increase the amount of the indebtedness against the home to prevent it possibly from being sold. Now there's a wrinkle here, and the courts are getting pretty wise to that, and it works like this. If you've got an outstanding home equity line of credit, okay, so you've encumbered the home for, say, another $100,000. So now, counting your trust deed at $100,000 and the home equity line of credit at another $100,000, there's nothing left. Well, if you get a judgment, if somebody gets a judgment against you, then there's some authority out there that the judgment creditor can now force you to draw down on that home equity line of credit. And the question is whether they're smart enough to know this or not at the time. Sometimes they'll take a look at the trust deeds and say, well, there's nothing there, so forget it. But if they look beyond the trust deeds, there's at least some authority that says if you haven't borrowed everything against the home and the money is still potentially sitting there to be borrowed, then they can potentially force you to go and draw down on that home equity line of credit to pay the judgment off. So it's not foolproof. Now, if you borrow the money against the home equity line of credit and you go and do something with it, or you spend it, or you drink it up, or gamble it away, tough luck. I mean, that's pretty much the judgment creditor can't get anything out of it. Okay. Now, what happens when you have people that are not married that live in a home? The rule in California is if you're not married, then you don't get the benefit of, first of all, you don't get to double the homestead exemption. Okay? But each individual person has an exemption equal to the amount of what they're entitled to. So if you get a judgment against two people, if it's a joint judgment against two people who are unmarried, then you can't double the exemption for both of those people because the judgment is against both of those people simultaneously. So all you get is one homestead exemption. But if each of them are unmarried and one gets a judgment against the other, then in terms of being able to protect the home, then the other party can assert a homestead exemption whenever the court goes to determine whether there's any equity left over at the end of the day to pay off the judgment creditor. Now, the other part that's kind of interesting about that is that if you have different forms of ownership in a home, community property, joint tenancy, tenancy in common, then if a judgment is rendered against one of the parties and not against the other, then all you can sell is that person's interest in the home. Now, they'd be entitled to the full amount of the homestead exemption, but if it's a joint tenancy interest, all you can sell is a joint tenant's interest, and all you can sell is the community property interest, or all you can sell is the tenancy in common. As a practical matter, nobody buys these things because nobody wants to buy a proportional owner or a fractional ownership in a home and try and use it because you can't sell it. Nobody really wants to buy something like that. They either want the whole home or they don't want anything at all. So, if you're living in a home, if you're living in a home and you're unmarried, it's probably not a bad idea to hold it as tenants in common. That's one of the ways to kind of potentially double the exemption and also defeat a possible sale of the house itself. Now, who qualifies? Anybody can qualify for the exemption if you just own a piece of real estate and you decide that that's going to be your home. You get the exemption whether you declare it or you don't declare it. It's always a good idea to go ahead and declare the exemption because you get some special benefits that comes from declaring the homestead. And I'll talk about those in a minute. But the exemption will apply regardless of whether you declare it or not. If you have a number of pieces of property, it's a smart idea to declare it because then you can choose which one you want to protect more than the others. And there are differences in terms of what people may want, to try and hang on to more than something else. The exemption would apply if somebody were to try and sell your home in an involuntary sale. Here's the wrinkle with respect to a declared homestead and one that's non-declared. If somebody gets a judgment against you and then they record the judgment so that it now attaches to the homestead. If you haven't declared the homestead, then the judgment will actually attach, and that's a legal construct that means that the judgment is now a part of the liens that apply against that property. If the property is then sold in a voluntary sale, okay? So that now, let's say you default on the note, and then the bank notices the property for foreclosure, and you've got a judgment creditor that's now coming after you. If you haven't declared the homestead, and you go in the 90-day period in which you're trying to sell the home, and you come up with a buyer that wants to buy the home. If you do a voluntary sale of the homestead, and it hasn't been declared during that 90-day period, then the proceeds of the sale will go to pay the judgment creditor ahead of your homestead exemption. If you do a voluntary sale, okay? If you do if an involuntary sale is being sought, and there's some extra proceeds over and above what your homestead exemption is, the exemption will apply whether you have declared it or not, okay? If you have declared the homestead, then from a legal standpoint, conceptually, a judgment that's recorded does not attach to the proceed, to the homestead itself. Okay, and that's important because what that means is if you then do a voluntary sale of your homestead, and you've got a declaration of homestead that's been recorded in the local county recorder's office, then what will happen is you can take out at the close of escrow, there will be an amount that's assigned to you commensurate to what your homestead exemption is, $50,000, $75,000, $150,000. And you can take that money and you can now go and buy another piece of property, another place to live at which you record a homestead, which you declare a homestead. And the recording of the homestead in the property that you buy now will actually reach back to the first date in which you declared the homestead in the first place. So what you're doing is you're tacking, you're adding on each time you move from one homestead to the next, if you record the homestead. As a pragmatic matter, what will happen if there's a close of escrow and you've got a declared homestead and there's a judgment creditor lurking around, the proceeds of the sale of the house are exempt from levy by the judgment creditor for a period of 6 months after there's been a sale if you have a declared homestead, okay? Whether it's voluntary or involuntary, it's still exempt for 6 months. The reason you declare is that you can actually do a voluntary sale and exempt the amount of the homestead exemption for that 6-month period to give you time to go buy another house. And that's important because, remember, if you're going to be selling the house and somebody's out there lurking around trying to collect the judgment, you can hang on to that amount of the exemption, and that provides a down payment for the next place where you're going to be living. So, and again, here's the other part. Let's say that the creditor can't levy against the house because when you add up the trust deeds and the homestead exemption, there's not anything left over to pay him off. Well, you can still effect a voluntary sale of your house and then take the proceeds over and above what the trust deed is and then go buy another house. That's the main reason why you want to declare the homestead. There's no real tax benefit for declaration of the homestead. I mean, it has no impact with respect to federal taxes or state taxes. It just provides a protection against judgment creditors who are now seeking to collect on a judgment that they've recorded, and they're chasing your home. Let's see, there's something else I want to cover. Management tendency, there's the fair market value. Voluntary sale. Let's see. I think that more or less covers most of what I wanted to talk about in the homestead exemption. I've attached the statutes for you all to review, and they're very easy to understand. You can read through these, and you'll know as much about this as I do right now. So it's not terribly complicated, and you can see exactly what you're entitled to and how to protect it, and what will happen if an order of sale is made against your dwelling. One of the things I would advise people is that anytime you buy any piece of residential property, what you should do is you should always ask to have a homestead declaration prepared as part of the closing. The escrow agents can do that. They know what these documents are, and I've actually attached a copy to the back of this, a copy of the homestead exemptions to the back of this homestead declaration to the back of this handout. So that's the document that you're looking for. It's a one-page document. You simply state that this residence, this property, is going to be your homestead, and then you record it just like you record the deed, and the deed of trust and any other documents that need to be recorded at the time of closing. One other thing there's a wrinkle here that often comes up whenever people are asking me about this, and I'll just raise it with you right now. A lot of realtors historically have advised people, married people, to take a property, when they take title to it, take the property in joint tenancy with right of survivorship. And historically it was kind of a poor person's will in terms of dealing with the property if one person were to die or another. It's an outdated conception in my view. There's still reasons for people to hold property in joint tenancy, but if you're a married couple, you're much better off holding property in the form of as community property. And there's a couple of reasons for that, and I just want to point them out. The first one is that it's just a lot harder to sell a community property interest if somebody gets a judgment against you. The regime has been fleshed out by the legislature in case decisions, and it's relatively recent and fairly modern. And there's just a good deal more protection for community property interest under the law in general than there are for joint tenancy interests. The other reason, and it has something to do with asset protection, but a community property interest is actually in the state of inheritance, which means that you can will a community property interest to somebody, and it can be passed, for example, to children. A joint tenancy interest is not in the state of inheritance. It's subject to being defeated by the death of the joint tenant if there's the other joint tenant, if there's a will that's out there. Because remember, joint tenancy, both parties have the right to possess all of the property all at the same time, and whoever dies last is the one that gets all of the property. So if your whole property is community property interest in the form of community property, then you can actually will it to someone. And that becomes important, probably more so in California than other places, because there are lots of blended marriages where you have children from previous relationships, and then you buy a house together, and then you have a community property interest that becomes important in terms of disposing of it. And then when you draw up a will or a living trust to divide up your estate, then you can leave a community property interest to children from a previous relationship if that's what you want to do. That's why that becomes somewhat significant. I can continue on with some of these other asset protection structures, or we can pause and talk about the homestead exemption right now if that's what you all would like to do. I'm happy to answer questions about that. Yes, sir.
So if you have a house that's paid off, it would probably be better than to do a family limited partnership?
Well, that's a structure that I put in here. It's a sophisticated structure, and I do these things, and they're very helpful if you're literally looking to lock up everything that you have. I've drawn out a schematic, a scheme of how these things work, and they couple with the general partner being, or a corporation, a closely held corporation being the general partner, and the stock is held by generally the family, some family members, and then you have a limited partnership with the individuals holding partnership interests. The benefits I've listed down here, and they're fairly straightforward with respect to that. You can only get a charging order against a partnership interest. In California, you can actually foreclose against a partnership interest. But the key thing is the general partner gets to manage the limited partnership, and if there's never any money that comes out in the form of distributions, then somebody that gets a judgment against one of the limited partners, all they get is a piece of paper, and what they may end up with is a taxable event without the money to pay the tax in the form of phantom income.
If the house is paid off, would you put the house in, or just put the house in an LLC?
The LLCs don't help that much. I mean, in this context, here's the problem with doing anything, any kind of asset protection. You got to do it before the event occurs. You have to plan ahead. If you put it into an LLC, you put some insulation between you and a judgment creditor, but you've got to respect that LLC, for business purposes. If you're going to try and defeat an effort to try and levy against the house, the short answer is there's not a lot of case law dealing with how LLCs are treated with respect to these kind of issues. It's a relatively new, phenomenon in California, and the partnership decisions have some application to the LLC laws. But as a lawyer, I would not advise you to put your house into an LLC and then rest easy at night. I mean, if you came into my office and you said, well, I've got, I have no trustees against my house, I've got a bunch of equity in it, what do I do? I'd say, well, you can try an LLC, but I'm not going to swear by it. You'll have to see what the courts will do. But I can tell you that if you drop it into a family limited partnership, then there's going to be a lot of case law that protects you and prevents that house from being sold, regardless of the amount of equity that you have in it. Good question? Yes.
If a lawsuit is filed against me and I don't have I have not homesteaded, and I'm concerned that I don't have adequate insurance or it may not cover the lawsuit, by virtue of the fact that the suit has already been filed, am I precluded from taking advantage?
I don't think so. No. I mean, that's an interesting question, and my reading of the case law is that you can declare a homestead anytime you want to. The important thing is to make sure that you're locked down in terms of you have a homestead. If you record before the judgment comes down, probably no problem. If you record after, well, you don't get the benefit of that because the lien has already attached to the house.
Right.
So if you smell a lawsuit coming, you better get busy. And in some respects, you always have to be careful about these last-minute arrangements because potentially they might be upset as fraudulent conveyances. But the recordation of a declaration of homestead before a judgment is rendered, still, under the case law that I've seen, it still protects that homestead, and you still get the benefit of the declared homestead. It's the judgment and the recordation of the judgment is the critical component.
Do you see a downside to homesteading?
None. Everybody ought to do it. It just ought to be automatic.
Do the family limited partnerships help at all with estate settlement? My parents passed away. We had 6 brothers and sisters, and all sorting out fine. But if you have that family partnership ahead of time, does that help in the
Absolutely. I mean, that's one of the bonuses of doing that. I mean, these vehicles have come into use relatively recently, and they're really the product of some very sophisticated lawyering that takes advantage of the interplay of state law, probate law, debtor-creditor law, partnership and corporation law, and tax law all at the same time. What you can do is, if you set one of these things up, you can drop whatever assets you want to into the family limited partnership, and then it's under the Internal Revenue Code. It's called a 351 transaction. So the partnership interest that you take back in return for what you drop into the partnership, that's a non-taxable event, because all you're doing is you're just putting assets in, taking paper back. So you don't pay tax whenever you do that. If you divide up, the ownership in the partnership, well, each of the partners now have a fractional ownership in whatever assets are in the partnership. And so let's say when the paterfamilias dies, then his estate is only going to, it's not going to include all of the assets that have now been put into the partnership, and there's not going to be a gift tax that's going to apply whenever those assets are put into the partnership because you haven't had a liquidation event. So what then happens is you can kind of do some estate planning, around some of the tax implications and divide up the ownership in the assets by putting the money or the property into a limited partnership, into a family limited partnership, and then fractionalizing the interest amongst all of the family members. I mean, for example, in our case, if you had a house that was worth $90,000 and you put it into the limited partnership, well, the husband would have $30,000. The wife would have $30,000, and then the child would have $30,000 in value in the partnership. And when the husband died, then for estate tax purposes, then only $30,000 of value would then go into his gross estate for purposes of paying estate tax. So a lot of these issues are becoming really academic because the estate tax exemption has gone up so high. It's up to $2 million now. So that pretty much effectively does away with a lot of estate planning for the bulk of people that are out there.
Does a family trust offer asset protection at all?
What do you mean by family trust?
Well, we would set up wills and a trust fund, trust account, whatever you call it.
A living trust?
For our daughter.
A living trust?
Uh-huh.
A living trust is only in the estate planning vehicle. It offers
No asset protection.
none. The only way
So can this be worked with in conjunction with that?
a family limited partnership,
Yeah, does it sort of hold the trust, or do you just throw out?
you wouldn't want the trust. It would be superfluous at that point in time. Well, let me rephrase that. There are good reasons for setting up living trusts. There are good probate and estate planning reasons for doing that. In terms of asset protection, living trusts offer no asset protection whatsoever. They're effectively a convenient vehicle for private disposition of assets in California, because if your estate is over and above what the small estate exception is under the probate code, then you've got to go through probate if you don't have a will, or if you do have a will, you have to go through probate if it's over and above the small estate exception. And living trusts provide a way to privately dispose of the assets once people die. The key to it is that living trusts are revocable during the lifetimes of the grantors, and then they become automatically irrevocable upon the death of the last to die. And then that's the liquidation event or the distribution event typically. But beyond that, in these living trusts, sometimes you have children that are fairly young, and you have sub-trusts that are set up. The sub-trusts that are set up on behalf of the children, those offer some asset protection, offer asset protection qualities, because what you're setting up for trust for the benefit of children, they typically carry spendthrift provisions, and the individual, the children themselves, don't have control over the assets. So if there's a judgment that's rendered against them and there's a spendthrift provision in the sub-trust, then the sub-trust is not going to be out there for purposes of satisfying that judgment. So it's not, living trusts in general are not asset protection vehicles. They are simply dispositional vehicles for estates, but they may have asset protection qualities to them depending upon whether there are sub-trust and spendthrift provisions after that takes. If you get a judgment against you and you've got a living trust, your stuff is just out there. Oftentimes what you'll see when I go to do these things, you'll see family limited partnerships or partnership interests that are part of an estate plan, and then you'll see a living trust, and as part of the holdings in the trust, you'll find a family limited partnership. And when you take a look at at this level down here, the partner level, the husband and the wife could take the partnership in the form of the partnership interest titled as trustees of the family trust. But that would just be it'd be an estate planning concept. It'd still have the same estate.
They could complement one another.
Absolutely. Yeah, because remember, you've got two separate functions. You've got, the family limited partnership, you can do a lot. Actually, if you dump all of your assets into the family limited partnership, you can actually do an estate plan just by how you divide up the fractional interest in the family limited partnership.
And this must cost $800 a year like any other corporate entity?
No, it's a private arrangement. Well, let me rephrase that. Excuse me. It is if you really want to do a great asset protection plan, you won't have a California family limited partnership. You'll go down to Texas, or you'll go down to Florida.
Same with the Homestead Exemption, go to Florida.
Precisely. The laws are just much better down there. For example, the family limited partnerships that I set up, they're Texas-based. And they're Texas-based for a couple of reasons. First of all, there's a guy down there that I've been doing business with for years who's just a master. And I trust him and I like him, and he really knows what he's doing. And these are his documents, and he knows how to defend them. The second part of that is that if there's going to be a challenge to the partnerships, then you got to go down to Texas to do it. So, Nevada resident, judgment gets rendered against him. Partnership interest, Texas-based partnership. Judgment creditor says, oh, okay, Texas-based partnership, okay, I'm going to go foreclose on his partnership interest. Okay, well, now he's got to go down to Texas to do that. He's got to get him a Texas lawyer. And you got to pay that Texas lawyer to go into the Texas courts and do something with his judgment. And he says, well, I want to foreclose. California law says I want to foreclose. And Texas says, nope. All you get is a charging order. That's all you get. You don't get to foreclose on the partnership interest. And what does a charging order mean? It means that if there's ever a distribution from the partnership, then you get to take whatever that guy is that you got the judgment against. So in our case, you got a 30% partnership. Texas law will give you a charging order. If there's a distribution in the partnership, then you get whatever he's entitled to. You don't get ownership of the partnership interest, so you can't take it and go sell it to somebody, right? And that's important because somebody might pay something for it. But if it's a charging order, you get something only if there's a distribution, and you cannot compel the partnership to make a distribution. You just have to get a charging order, and you have to wait and see if somebody pays some money out. If they don't, you got nothing. Here's the poison pill. What if you get a charging order, okay, or even more dramatically in California, you foreclose on the partnership interest, so now you actually own the partnership interest. And the general partner, who is probably one of the people that you got the judgment against, or they own the stock in the general partner, they decide, okay, well, we're going to give you your K1. Here's the amount of income that the partnership earned during this year. But we don't think it's a great idea to make any distributions. It's been a tough year. So all of a sudden, you have a tax event. You've got taxable income that you've got to report on your 1040 for $30,000, but you don't get any cash to pay the $30,000 tax liability. That's real. Well, they usually want to sell that partnership interest back whenever they find that out.
For investments outside the family assets, that's where you use an LLC. Is that right?
Well, this is a vehicle that you can use for everything. I mean, ideally, these things work best where obviously where you have a very close-knit family where everybody's talking to each other and everybody's cooperating, and I mean that's the necessary condition before you even think about doing one of these things. If you've got a family where there's problems, communication problems, or you've got someone that's could be anything. Well, you want to pause before you think about doing something like this, because remember, when you set up a partnership, you're going to be creating legal rights for these people. And typically, you need to make sure that your children understand what you're doing, and they're sophisticated enough to know this, and everybody's on board for trying to protect the family wealth. If it turns out that you've got a partner out there that that all of a sudden they get a taste for methamphetamine, well, you got a problem. So you need to be thinking ahead. These things, it's not one size fits all for everybody. I mean, that's why you need to, that's why you don't see these family limited partnerships as documents that you can download from the internet, because it requires a really sophisticated analysis of what your individual family position is and what you're trying to do in the long run.
One more question.
Sure.
A minor child is a beneficiary of the trust now. Would they still be in this position, or would they be beneficiary of the trust and then the two parents would be partners?
Well, what you'd probably do is, if you set one of these up and you had minor children, the living trust would be something that would be separate from the family limited partnership, okay? And when you're talking about who owns the partnership interest, what would probably happen is that the parents would would hold the partnership interest as guardians for the child.
Okay, so the child still would be a 1/3 partner.
Yes, and that's important. That's actually the key to this stuff, because what occurs is this. Typically if you've got a family limited partnership in place, then you have husbands and wives that are out there doing things, making money, and potentially getting sued. That's usually what happens. But the children aren't, okay? And if they're adult children, even better. I mean, they're just out there doing whatever they're going to do. You can play around with the ownership in the partnership. I mean, for example, I've got one right now where the husband and wife own collectively 90%. No, excuse me. Yeah, 90% of the partnership interests between them. And then the two children each own 2.5%, and then the general partner owns 5%, because the general partner has to have something in the partnership in order to manage it. Well, the husband and wife are being chased by a judgment creditor. Long time ago. This thing was in place many years. Judgment creditor now is chasing them down on these private judgments, but because the children are partners in the partnership and they have equal legal rights regardless of what their ownership is, what their financial interest is in the partnership. Well, then you can shut down any inquiries about what the operations of the partnership are by asserting the individual partners, the children's individual partnership rights vis-a-vis a third-party judgment creditor who doesn't have a judgment against the partnership. You see? So the children's rights in this case become critical because they're the ones, whenever you have a showdown with a judgment creditor, they're the ones whose rights you're protecting in the form of preventing the disclosure of documents relating to the operations of the partnership.
Is that because the courts view them as an innocent third party?
To some extent. That's a good way of putting it, but effectively what you've got, I mean, practically speaking, somebody has a judgment against individuals, but they don't have a judgment against the partnership. And the partnership is a separate legal entity. Now the key to this stuff, just like running a small corporation, is you better do your housekeeping. I mean, if you play with this like it's a piggy bank, then the court will just blow right through it. And they'll say, no, there's no distinction between you and this partnership. We're going to pierce the veil. So, it requires some housekeeping, and it also requires, if you're going to be running one of these things, it really requires, a lawyer who really knows what they're doing as they advise you to, as you're making moves. These things it's interesting, the history of these things, they got started down in Texas many years ago. There were some big tycoons that had a lot of oil wealth that were looking for ways to effectively protect what they'd already made, and they went into some lawyers in Dallas and Houston, and these guys got together and they put these things together because basically they're protecting family empires. And now, because they've become the documents have become somewhat more routinized, and the prices have come down for doing these things, then it's become more available to people than it was before. And in California, the real estate values are high. That walking along the street, you almost see millionaires everywhere you go. So there's some. It's interesting. Let me talk about this in the context of the homestead exemption in one of these family limited partnerships. Maybe it would be best to describe it this way. Sometimes it's a good idea to leave the house outside of the family limited partnership. And it goes this. Look, if you dump everything into a family limited partnership and you're right on the eve of a lawsuit coming down, then it looks like that you've really done a fraudulent conveyance. And you have to be careful, because if you do that, you have to justify, if you're right on the eve of a lawsuit, you have to justify everything you do as having a business purpose. And if you put everything in there, then the court may look at that and they say, look, you're just trying to defeat this guy who's about to sue you, so we don't necessarily think that's a great idea. So not only are we going to say your house is on the block, but everything you put in this partnership is on the block. So you have to be careful about timing. If you leave the house out, you still have a homestead exemption, right? So that protects a certain portion of the equity, and more than likely you've got a trust deed that's out there. But if you have a home equity line of credit against the house, and it's in the name of the individual, what if you borrow against the home equity line of credit, and you use the borrowings from the home equity line of credit to fund the limited partnership? Right? Because now what you've done is you've already had a pre-established home equity line of credit. You're just borrowing the assets because you've got this estate planning vehicle, and this is a great idea for your family. And since real estate prices are going up, the banks will loan you the money, so you borrow against your home equity line of credit, and you use that to fund the establishment of the limited partnership. Now what happens is you've got trust deed number 1, which is in place. You've got trust deed number 2, which encompasses the home equity line of credit, and you've got the homestead exemption, right? So you can effectively cover all of the equity in a home if you do it in that fashion. And the final piece to it is this. Usually in these family limited partnerships, these are business vehicles. And you can also do something which I like is kind of a master stroke. You can enter into a loan agreement with your own family limited partnership, whereby the family limited partnership will loan you money, all right, and you record a trust deed in the name of the family limited partnership against your home. If the loan agreement that you have, which has to be it has to be evidenced by notes, and you have to have authorization of the board of directors and the partners to do these transactions. But if the loan agreement or the notes indicate that additional loans are, you have authority for additional loans, and they're secured by the trust deed that you have recorded, what you have effectively done is create a totally flexible line of credit where you can borrow as much as you need to, and the priority for those loans relates back to the recordation of that trust deed. So
The house is still outside.
house is still outside. See, if it's inside, you can't do that. But instead, what you've got is you've got a non-arm's length transaction, which you can still justify for a business purpose if you need to get money out. And then the final piece, the final piece of the puzzle can float depending upon the size of the loan that you decide to take out. And you can take out additional loans with the priority established by the trust deed that you've already put in place. Because the trust deed would secure any additional borrowings with respect to that loan agreement that you have with the family limited partnership. And I'm going to bet you're not going to have too much trouble approving a loan from the family limited partnership.
If one of the family members has passed away, do you still do a family limited partnership with the estate? Is that...
No. Let me say this. Conceptually, I guess you could, but that would be too complicated. And you really wouldn't want to do that because you're already... The idea behind these arrangements is that they are private arrangements and they have a degree of secrecy tied to them, not in a negative sense, but these are confidential documents that don't ever see the light of day, other than the filing of a certificate of limited partnership with the state and articles of incorporation for the general partner. All the other documents stay private, and that's important too because let's think about this. If you were to go, if a judgment were rendered against you and you went to a creditor's examination, order of examination up here in Department 6 or 7? 6. And then you're sworn in, go back into the back room, and the creditor's there asking you questions. And he says, well, okay, what do you have? I said, well, I've got a car and I've got this house. Here's the homestead. We've got trust deeds because we had financial trouble. We had to borrow a bunch of money. Usually you do. You got to borrow money to pay lawyers to defend you in the lawsuit, right? But then you say, and I've got this partnership interest. You say, what? You say, yeah, it's got a partnership interest. Well, what is it? It's the Guyton family partnership. Ideally, you'll pick a name that will have some distance from you and the partnership. You call it the SPD partnership. And they say, well, what does that consist of? Well, it's just a partnership interest. And you say, okay, well, show me the books. And say, all of a sudden, the lawyer who represents the family limited partnership, not the same lawyer representing you in your individual capacity, but the lawyer representing the family limited partnership says, no, those are confidential documents. We're not going to release that. And because the partnership is not a judgment debtor, then the inquiry stops there. So you don't have to say anything about what's happening in this partnership. Or if you do, well, they'd be subject to a motion to quash. Because again, remember, you've got a separate legal entity that's out there. You may have a showdown in front of a judge, but where's the showdown going to take place? Exactly.
On the note you have here by the distribution of proceeds, you've written homeowner's exemption. Now, isn't that to do with ad valorem tax?
No.
To do with homesteading?
No, I'm sorry. No, that...
Number 2.
Yeah. No, I'm sorry. That's the... No, I just used a different word. That is the homestead exemption.
Should be homestead.
Yes, the homeowners. Well, look at item number 2. It says, to the judgment debtor in the amount of any applicable exemption of proceeds. That is the homestead exemption.
Okay.
The point about that is that when you go to determine the priorities of who gets what and whether a home can be sold, you add up everything except for the judgment debt, and that comes at the bottom.
But
And
there is a difference between homestead and homeowners exemption.
no, I'm sorry. Don't take that from here. It's the homestead exemption. It is the homeowner's exemption of the proceeds that's in the house. It's the same thing. It's just I used a different term in my notes there.
Okay, because when you file with the county assessor's office,
Right.
homeowners exemption.
That's what I was saying. The homestead exemption does not deal with tax issues, okay? You have a certain amount that you can exempt from taxation as a function of property taxes, but that's not what's at stake here. This is just the exemption that's available for purposes of determining how much a judgment creditor can get out of a forced sale of the home. Anybody else? Yes, sir.
If you buy a piece of real estate and it's put, say you pay cash for it and you put it in an irrevocable trust, is that property then protected from creditors if, like the trustee, say somebody comes after the trustee?
Who is
Can't
the
come after that property in the trust. can they?
well? First of all, who is the trustee of the irrevocable trust? Who's the trustee? Is it a bank or is it
No, an individual,
the person who put the home in?
yeah.
Well, that's where it begins to get squirrely. Who's the beneficiary of the trust?
Well, it could be the trustee.
Okay. Let me see if I can get this clear. If you put the home into an irrevocable trust, you are the trustee, you are the beneficiary of the trust, right? So the only thing that's happened is that you've now put the home into an irrevocable trust, right? I don't think that's going to help. You've got an irrevocable trust, it's a trust in name only, but because you're the trustee and you're also the beneficiary, I think what happens when you have a showdown on whether a judgment creditor can reach the home, the court is going to look to that and say there's a unity of interest between you and that trust. You call it irrevocable, but basically the benefits are yours. All you're doing is trying to prevent a judgment creditor from reaching you in that case. Now, if you take the home and you put it into an irrevocable trust, and the beneficiaries of the trust are the children, okay, well then it begins to look more like what you've done is actually separate your control and ownership of the property and you put it in the hands of somebody else. Well then, yes, that probably has some asset protection quality to it. I can't tell you how much. Every case turns on its own facts, and it also, critically, it also depends upon what was the intent of doing that transaction and how close to a judgment was that transaction done.
Well, that's spelled out, the intent is spelled out in the trust.
Yes, that helps, yes. But think about this. I can create a trust document that says, here's what we're going to do, this is the reason we're going to do it, and that may be fine. But if that's 2 days away from when a judgment is rendered, a court's going to...
That wouldn't be the case.
Right.
But let's say that the trust was formed in one person's name, is so-and-so's trust, and they're the trustee, and they pass away, and then the beneficiary takes control of the trust and becomes a trustee.
Mm-hmm.
Now, the new trustee or beneficiary is not in the first position when this trust was formed and when the property was put in the trust name.
Mm-hmm. Mm-hmm.
Is that a better situation?
It looks better. I can't, the problem with these things is that we know this for sure. There's a statutory scheme that tells you what happens if you have a showdown on your homestead exemption. We can look at the statutes and we know exactly what's going to happen there. When you put properties in trust, typically what courts are going to be looking for is there another reason besides simply trying to defeat a creditor for the establishment of that trust. See that, then you'll have a much stronger argument to be able to tell a judge that no, we established this many years ago because we have the family property and we wanted to leave it to the kids. We just wanted to live there. We wanted to have a life estate in the property effectively. And then we want ultimately the children to have it. And yeah, at that time, 20 years ago before this lawsuit came down, we wanted to make sure that it would go into their hands. You'd probably be okay with that.
Then you cannot put that property that's recorded in the county in a trust under home exemption.
Well, I mean, but see, watch this. I mean, because that gets a little strange too. Because remember that the homestead exemption applies for you, right? If you deed the property over to an irrevocable trust, the irrevocable trust now becomes the legal owner of the property, right? And so now, who has to record the homestead exemption?
The trustee.
On behalf of the trust and the children who are actually the beneficial owners of the property. So you lose your homestead exemption as an individual, right? Because you don't have a home. Right.
So you can't do both.
Yeah, exactly. What you can do, I mean, sometimes, I mean, it depends on what people want to do. You can do a life estate, right? You can say, look, I just want to live in the home. I mean, this is kind of a shortcut way to get to where you're going. I just want to live in the home during my life. I don't ever want to do anything other than that, and I'm going to give the remainder to the children. Then what you have is a life estate, and you know, you can actually, it's actually an estate of that you can go ahead and foreclose on that life estate, and they can do that. And then they take the life estate and they say, okay, well, everybody else that's living in the house, you got to go, because now I own the life estate. So kids, grandma, mother-in-law, you go find somewhere else to live, because I'm going to rent that house out and I'm going to collect the rent from that property during the life of the guy that I just got the judgment against. So, I mean, you can do that, but it gets kind of tricky. There are other consequences. That a lot of this stuff, you know, to be honest with you, you know, I gave you some in the handout here. I gave you some homemade asset protection techniques, and these are fairly simple. And you know, they're to some extent. Think about this: when you've got money, I mean, money's fungible. You can only do two things with it. You can either you can make it disappear. I mean, literally, you can go and you can convert everything into bearer bonds, and then get on a plane and fly out of the country, and it's gone. You can make it disappear, or you can in the trade we call it ugly it all up, so that, you know, if you put a bunch of barriers between the money and the creditor, then it's like, you know, it's like digging into a porcupine. Every time you go something, then you got another problem there. And eventually what you're looking for in the long run is, if you get a judgment against you, you're looking for somebody to come and settle it out. You know, when they take a look and see what's actually there and what they can actually get and how much it's going to cost to get it, then you say, okay, well, here, we'll give you some go-away money. Here, take that. You know, $100,000 judgment. Here, take $10,000 because it's going to cost you $50,000 to get an additional $20,000 or something. I mean, it becomes a real economic calculation at that point in time. So what you do is you can make assets disappear. I do some of these offshore arrangements, which are really interesting. And bear in mind, I mean, I'm not Robert Vesco or Michael Milken, but you know, I do some of this work, and the key to that is that, you know, you got to have a lot of money to make it worthwhile to do something like that. And there are some problems, especially now in the post 9/11 world, in terms of setting these things up, because the government's looking more carefully at these things. You're not doing it for tax purposes. Some people think that, well, look, if I just put the money overseas, then I can, you know, avoid taxes. Here's the problem. You can earn income overseas, but you got to get it here to use it. And when it comes in, I mean, it can be out there accumulating as much as you want it to, but you got to bring it here in order to use it. And when you bring it in, you've got a taxable event if you do it legally, and I'm not going to do it any other way. I mean, that's what I tell people. They come to me and they want to, you know, they want to do something funky from a tax standpoint. I say, here's what we can do, but you're going to pay taxes on whatever you bring into the country.
One more question. Say somebody has a judgment against you in Nevada County, and they record that judgment lien or whatever it is for money you owe in Nevada County. If you own property in another county in California, does that judgment lien carry over to the other counties?
You have to. That's a good question. You actually, in order for the lien to attach to real estate, you have to record that judgment in each county in which pieces of real estate are located. Okay.
So you have a judgment lien recorded in Sierra County, but not Nevada County. You own real estate in Nevada County. It doesn't encumber that real estate.
That's correct. That's correct. Now, the other wrinkle to that is that the judgment lien, if it's recorded, and then potentially it attaches to bank accounts and personal property if it's recorded. Well, certainly in the county. I mean, your question is, does it attach outside? And the short answer is, I think it does. But then it becomes a question of people going to find those assets. And typically when I've gotten judgments and I've recorded them, and usually in California, here's the inside dope. If you get a judgment against somebody and you record it, you know they've got some real estate somewhere, and you find out where that real estate is, either by virtue of, sometimes you find this out in the context of a lawsuit, or if you know where somebody's living, then you know for certain they have real estate there. Or if you do a creditor's examinations, what's called an order of examination, where they have to come in and answer questions, then you can find out where they may have real estate. If you record those judgments in those counties where you know that there's real estate, then you've got two things. It's like a trust deed. I mean, the fellow has the homestead exemption, but with the run-up in real estate prices, eventually you're going to get some money out of that judgment if you sit tight. And plus, you're going to be earning 10% per year on the judgment, not compound, it's only simple. But 10% per year on what is a totally secure investment in California is not too bad. The only thing that can happen that may be bad, maybe he defaults on the trust deed, and then the secure lender comes in, forecloses on the property, and then cuts you off. But if they hang on to the property long enough, then you get paid either when they do a refinance or when they sell the property. There you are. And I've got one right now where that happened. Oh, by the way, here's the other thing. This is important too. Family support orders are judgments for arrears that you typically find a lot in Nevada County. The homestead exemption does not apply against those. Those orders either for child support or spousal support, judgments in that they have super priority. So the only thing that comes ahead of them, if they are recorded, is the consensual liens, the trust deeds. It does not protect against a judgment for family support, and that's good. That's the way it ought to be.
So I'm a unmarried joint tenant, and what I heard is basically the homestead exemption is really not that useful for us because the joint tenancy makes it complicated for somebody to put a lien against.
It adds a wrinkle to it. I mean, here's the rule. Here's the problem with holding property in joint tenancy. Joint tenancy means that everybody owns everything all at the same time. You can't will the property to somebody else.
So even if we had a will, we do have 4 children between us, and we have a separate will, but it's just our own written.
Well, remember that the joint tenancy interest is not going to pass under the will, right?
So tenants in common would be a lot more useful.
Well, no. Well, if you're not married, then you can't hold it as community property, right?
Right.
Right.
So
Here's the point. No, it's a very good question because let me see if I can focus in on it. A joint tenancy or a joint tenant has the right to own the property during their lifetime. At the end of their lifetime, the joint tenancy ends legally, and the other joint tenant becomes entitled to own everything.
Right.
Okay, so it just terminates by operation of law. Although both joint tenants have the right during their lifetime to own all of the property. You see? You don't divide it. It's just each joint tenant has the legal right to own every single particle of that property during their lifetime.
Right.
Which means that if a judgment is rendered against a joint tenant, okay,
Right.
the judgment attaches against all of the property, right? Regardless of what your joint tenancy interest is, if you go to sell the property later on,
Right.
then the judgment would attach against all of that joint tenancy if you do a voluntary sale, right? Now, here's the more sophisticated question. What happens if there's a judgment creditor that records a judgment? I've got a joint tenancy interest, okay, and we have a declared homestead. So that I'm a joint tenant, I'm living in this property, I've got children with my other joint tenant, we're all living there together. What does that mean in terms of what I get if the judgment creditor goes to chase after the guy who's got the judgment against him? The short answer is you only get one homestead exemption. So you don't get to double it just because you're joint tenants and unmarried,
Right.
right? But the judgment creditor can only levy against and sell the joint tenancy interest of the guy who's living there,
Right.
right?
Right.
So you still get the right to live there,
Uh-huh.
right?
So they can encumber the lien, they can put a lien on the property, they can't force you to sell it, but they can encumber the
Well, you
title.
can. Well, no. You can force a sale
Uh-huh.
of a joint tenancy interest, but all you can force a sale of is the joint tenancy interest. And since it's a homestead, subject to all of the rules about what it takes to sell a homestead.
Uh-huh.
The short answer is, and this is the way it goes, nobody buys a joint tenancy interest.
Right.
Why would you? Because you still have the right to live there.
Uh-huh.
If your significant other gets a judgment against him, and then they go ahead and they go through this process and say there's enough equity so that maybe the judgment creditor gets something at the tail end of it.
Right.
Who wants to own that joint tenancy interest?
Right.
Who wants to?
Right.
Does a quitclaim deed sort of at the last moment protect the other joint tenant?
Not necessarily. I mean, any transaction that happens at the last minute before a judgment comes down, other than the recordation of a declared homestead, is going to be viewed with suspicion. So you're always subject to having any transaction, whether it's the gift of property to a child, transfer of ownership of property to grandparent or something. Those are always potentially undoable as fraudulent conveyances. And unfortunately, what happens for most people is that they all of a sudden realize they have a problem right when it's on the eve of a problem about to occur. I mean, if you're thinking about this in the long term, which is what you ought to do, you ought to be coming in to see a lawyer and say, well, we may have this problem out there. What can we do to prevent this or deal with this problem if it does occur? And then the lawyer can give you some assessment about, well, is this a real problem, or is this is this a bogeyman?
Well, yeah, I mean, this would be in anticipation of an unknown problem.
Correct. But I mean, the short answer to that is that if you're basically retired and you're living on a fixed income, then barring an automobile accident, you're probably not going to have a judgment creditor coming after you, right? If you're 45 years old and you're out there doing things and building wealth and making money, then potentially you're going to be involved in situations where somebody might end up suing you, aside from having an automobile accident. And then that be the case, there's a real premium, especially if you have large transactions, to perhaps doing business in the family limited partnership form, because family limited partnership is a separate entity. They can take title to everything out there. And what you're doing as you're building wealth is you're actually affecting an estate plan, because each of the family members are now going to have a proportionate share of whatever the wealth is that you're building. So it's not just asset protection that one of these structures, you're basically going into business, and you're conceptualizing whatever money comes in is not his or hers or the kids, it's just family wealth. These things work marvelously where you have intact families with people that are closely cooperating and everybody is on the same game plan. It's a total disaster if you have a dysfunctional family. I mean